Hi, I hope you can hear me okay. I'm Stephen Tromans, broadcasting not from 39 Essex Chambers, but in principle from 39 Essex Chambers with 39 minutes of updating for you. So you've got with me my colleagues Celina and Rachel. Hello both. I'm not going to spend time introducing them because if you want to look them up, go onto our website and you will have their full biographies and details of cases they've done, etc., etc. So this is the 9th, I think, in the series of such events we've done. The idea is, as before, we offer you round about 39 minutes from the three of us with an opportunity for questions on the topics we're going to cover. Could you please use the questions button on your screen to ask any questions? You can either ask them anonymously or you can leave your name. If you do give your name, we're not going to say your name if we answer the question. We will do our best one way or another, either online or offline, to answer the questions you put. So I think that's really all I want to say. I'm going to share the screen now and then we'll get going. So slideshow from beginning, and there we are. So the topics we're going to cover, you've had my chair's introduction. Celina is going to cover the state of play on air quality and the various cases on that, some of which she's been involved in. Rachel is going to cover case law on the topic of climate change. And then I've got a few odds and sods. Well, they're more than odds and sods, really. There's a number of Court of Appeal cases at the end, which may be of interest to you. So I'm in charge. Very rashly, they've entrusted me with a button that moves on the slides. So if I fall asleep, you'll know nothing is happening. They'll shout and wake me up. But I'm going to move it on to Celina to take us through our first session. Okay.
Thank you very much, Stephen. Welcome to my kitchen, everybody. I did want to try and get Chambers to do this so you could have a sort of more professional background, but my site visit went on for a bit long, so you've got me in the kitchen. Air quality is a vast subject, but I'm going to try and condense my talk into the requisite under 10 minutes. It's going to be in two parts. What I do is try and just give you a run through of and identify the legal framework and the principal cases and just touch on what they meant. And thereafter, we'll look at the environmental bill and see where we are going. Thank you, Stephen. I think I'm on the first slide. So the first thing to be aware, as we all are, is the government, it has said for some considerable time that it wants to be seen as maintaining issues of air pollution and tackling them. One of the principal policy announcements right at the beginning of its fact sheet on an environmental bill is where they're fully committed to tackling air pollution. And that is independent of being a member of the EU. I thought that was a rather odd phrase, but that is clearly a commitment. The other quote I thought I might give you at the beginning before we launch into more details of the framework are the comments from Mr. Justice Garnham in ClientEarth 3, who said, I think, what we all feel about the nature of the law on air quality, which is that proper and timely compliance with the law in this field matters. It matters first because the government is as much a subject of law as any citizen or any other body in the UK. It is obliged to comply with the directive and the regulations and obviously with the orders of the court. And secondly, it matters because, as is common ground between all the parties to this litigation, a failure to comply with these legal requirements exposes the citizens of the UK to a real and persistent risk of significant harm. And that is something that I find quite striking about air quality. And it may be that the air quality is so particularly contentious because people can feel it and see it far more perhaps than some of the other polluting issues such as climate change, although that is a global issue. But my view is that air quality is one of those that's gained traction far more fundamentally. Anyway, let's quickly go through the framework. Obviously, the Air Quality Directive, which sets out the legally binding limits for concentrations in respect of major air pollutants and those that impact on health, including PM10 and PM2.5, which is obviously the worst in effect in terms of health, and NO2. And obviously requires action to be taken in respect of the Air Quality Directive. I will deal with why I've said a general requires when I come to look at Shirley and ClientEarth. Obviously the air quality standards, and thereafter we've got the Environment Act, which deals with the local air quality management regime, which is where the local authorities come in, obviously, and not on a national basis. And lastly, I've mentioned the Clean Air Act. It's not one that gains too much attention, but it is mentioned in the Environment Bill, so I've mentioned it there. Thank you very much, Stephen. So essential cases, the series of ClientEarth cases, I always say that they begin with the reference back in 2015 to the Commission, and then the Supreme Court dealt with it when ClientEarth first challenged the way that the UK was failing to meet the directives and the limitations. And in particular, the Supreme Court said this is not a matter for Commission, this is something that can be made justiciable in this country. ClientEarths 1, 2 and 3, they dealt with the series of national air quality policies that came out and kept referring back to the relevant articles of the Air Quality Directive, in particular 23 and 26, and that they had failed in particular to meet the correct plan to achieve the right limits by the right time, and that they had in effect also failed to fully explain how it was going to be implemented. So then next slide, please, Stephen. After Shirley, after ClientEarth, there have been a couple of cases which I had the chance to be involved in. I've called them Shirley 1 and 2. Shirley 2 you may not have heard of because ultimately it had to be adjourned because of the Shirley 1 going to the Court of Appeal. The Shirley cases deal with a specific type of interpretation of the Air Quality Directive. Shirley 1 dealt with trying to, in effect, get Secretary of State to take responsibility for very large developments, as 4,000 unit development, and so that it had to be called in. And the reason that it had to be called in was because of the likely impact on air quality. And that it had to be, in Ms. Shirley's view, something that the Secretary of State should decide. Now, both the High Court, Mr. Justice Dove, and the Court of Appeal rejected that idea, and in particular said the Air Quality Directive's purpose, in effect, is where there are breaches. The response to that is not to make decisions, but to put a plan together and then implement it. In other words, what came out of ClientEarth, but it didn't go further. What it did say, however, what both Mr. Justice Dove and Mr. Lord Lindblom said was that clearly air quality is a material consideration, but that is not the same as saying something, because of a consequence of the Air Quality Directive, requires a specific act on the Secretary of State's behalf in planning matters. Gladman is interesting because it came in between, I can't remember which, I think it was ClientEarth 2 and 3, and that dealt with the system that had been in place and at the moment still operates, whereby mitigation for air quality is dealt with through a sort of sausage machine. You put in your air quality factors, and out comes the money that you need to put towards the mitigation. I am oversimplifying, but I think the most important thing that came out of it was that you couldn't assume simply that the government was going to comply with the Air Quality Directive, because it hadn't by that particular time. And secondly, that if you were going to rely on the process whereby you ended up with the money you were going to put towards your mitigation, you needed to show that there was actual measures that you were thinking about. You couldn't just say, here's some money, local authority, put that towards mitigating measures. So there was because there had not been sufficient explanation or sufficient plan put before the inspector, he said, look, I can't accept that the air quality issues in this case is acceptable. Shirley 2, which is the one that I dealt with in particular, dealt with a notion that local plans themselves should be addressed on a very specific basis in order to address the Air Quality Directive, and that they had to show in terms of policy, on draft policy, that the air quality limitations would be met. Now, that also we argued should be rejected, because we had the interpretation of the Air Quality Directive from Shirley 1, and ultimately Ms. Shirley decided to consent. We had a small issue about one wording, but that matter was resolved at the beginning of the year. Next slide, please. Now, Spurrier was one of the Heathrow runway NPS challenge claimants. And in particular, whilst obviously the arguments were wider, Spurrier dealt with air quality. And their argument was that the decision to designate the NPS was unlawful because the modelling showed that the air quality limitations, the Air Quality Directive, could not be met. And the court rather interestingly said, well, it says very clearly that you've got to comply with limitations, and that if it doesn't, then clearly there would be a breach. So you're telling us it's impossible, but this is about the nature of the NPS, not whether this development can actually ever meet those challenges. So that was an interesting one, but the Court of Appeal, Spurrier decided not to go to the Court of Appeal, and as we know, Spurrier was successful on other grounds. I'm sure Rachel will look at that. And the last little NB I put there is the challenge to the to risk 2 by the Transport Action Network, and that is, I think, we're trying to return to the notion of the Air Quality Directive being interpreted in a much more direct way. So watch this space on that. Thank you, Stephen. So the basic principles that we've got is that the Air Quality Directive has binding commitments aimed at defining and establishing objectives for ambient air. Article 1, and indeed maintaining air quality where it's good and improving in other cases, Article 1.5. Next slide, please. In terms of the principle, again, the Air Quality Directive and air quality plans, the air quality plans is what comes out of the ClientEarth litigation. Shirley and Gladman deal with planning considerations, as I've said, and I've mentioned Spurrier there as well as Shirley. Next slide, please. So where are we going? I'm sorry, my Latin teacher would wrap me on the knuckles. It's not quo vadis, which is you, it's quo vadimus. But where are we going? 2017, we've got, again, in response to ClientEarth, there was a specific plan put forward about tackling NO2. And that has been put in place, and that survived challenge. 2019, we have the Clean Air Strategy, and again, that to some extent survived the ClientEarth challenge and is still in place. But in particular, what we have now is the Environment Bill. Thank you, Stephen. The Environment Bill, the parts of that to keep an eye on are firstly in the environmental governance first part, clauses 1 and 2. Firstly, it sets 2 duties about targets. Air quality is the only one that has a very specific one that it's set in terms of PM 2.5. Air quality is one of the many priority areas that are to be the subject of targets that are set. But secondly, there is not only a specific target in relation to lowering PM 2.5s, but also there should be a long-term target across air quality issues that is to cover a period of a minimum of 15 years. There is also a Secretary of State duty to ensure that PM 2.5 target is met, as well as general across the board duties. Thank you very much, Stephen. Now, part 4 of the bill it deals specifically with air quality and motor vehicle recall. It's a rather bit of a mishmash. Schedule 11 of the bill sets out amendments to the local air quality management regime. It doesn't really change the regime too much. Clearly, authorities still have a duty to set out a plan when they've got breaches of limitations, as is the current regime now, and also to set those management areas. But what is new is the notion of a duty to cooperate with neighbouring authorities in terms of trying to achieve those limitations. So that's an interesting new part of the regime. So that will be amend the 95 Act. In terms of the Clean Air Act, it's again setting various levels and various processes whereby people should keep an eye on solid fuels, etc. The more interesting one for me anyway is this business about giving bodies the power and indeed businesses the power to recall vehicles that have been shown to breach the limitation values, and I'm trying to enforce that through a sort of penalty system, etc., is going to be an interesting one. And at the moment, it doesn't look as if the OEP is going to deal with it, but we shall see. Thank you, Stephen. And lastly, I thought I'd just show you 2 slides. I know many of us have throughout the quarantine period been aware of the differences in terms of air quality. This photograph is obviously of London in 2016, and as you can probably understand, that the blue and green bits around the edge are where where air quality is good, and clearly in the middle, where I am at the moment, is pretty bad. If you look at the last slide, Stephen, that was Monday morning. So a very significant effect from Corona, and I have a suspicion that will change, but for the moment, all is good in the middle of central London and its regions. Thank you very much. Over to you, Rachel.
Thank you. Thanks, Celina. Thank you, Stephen, for bringing up my slide. I'm going to address, hopefully I've just had the nightmare notification that internet connection is unstable, so hopefully I will get through my 10-minute slot. But I'm going to address a couple of domestic cases which have sought to raise challenges concerning climate change issues this year. Obviously there are other cases worldwide going on, but I just don't have time, I'm afraid, to cover everything in this slot. Stephen, if I could go to the next slide, thank you. So the big case, the starting point for this year has been the Plan B Earth case in the Court of Appeal, which is the Heathrow third runway. Celina touched on this when it was in front of the High Court of Spuria. There were more issues than just climate change, even at the Court of Appeal. It's a long, but it's an interesting judgment. And if there's anyone who's not read it yet, wholeheartedly recommend it as light bedtime reading. Great fun. The climate change grounds were put in various ways, all of which succeeded, but effectively amounted to a challenge to the lawfulness of the government having failed to take into account its commitments under the Paris Agreement. At the time, the Climate Change Act set a limit for at least 80% reduction on 1990 levels of greenhouse gas emissions by 2050, consistent with a global temperature limit of 2 degrees. That's been amended now last year, so it's no longer that, but that's what it was at the time. The Paris Agreement sets a rather more onerous, it commits to more onerous restrictions on the basis that the increase in restricting the increase of global temperatures to well below 2 degrees. The Secretary of State accepted that they hadn't taken the Paris Agreement into account when they were designating the AMPS, and so it wasn't controversial that it simply hadn't been considered. The question was whether it ought to have been. As I say, that was put in a number of ways. You see there section 5.8 and sections 10.3 of the Planning Act. Section 5.8 is the requirement that national policy statements have to include an explanation as to how the policy they set out takes into account government policy relating to the mitigation of and adaptation to climate change. The question there was whether government policy included matters which weren't set out in statute, but which were matters the government had publicly committed to. So it was not controversial that the government had committed to the Paris Agreement. It was expressly part of national policy in broad term, that would be the case, but what it wasn't at that point was something that you could point to in the Climate Change Act and say, well, that's where you find it. And the Court of Appeal said, well, that's fine. There's no particular magic to the words government policy, they're ordinary words. And we're not going, by requiring the government to having regard to its commitments, all that's being required is, in this case, an explanation of how it's been taken into account. It's not a requirement that it sticks to those commitments. It's simply it's a standard public law principle that if Parliament has said you do something, then you ought to be doing it. It was also held that that wasn't inconsistent with the Climate Change Act to 80%, because that was at least an 80% reduction, and so an explanation of how you intended to meet or didn't intend to meet, but how you had at least addressed your mind to the fact that government policy was for a greater commitment, didn't cause any issues with the Climate Change Act. Just quickly, the other points that were raised, section 10.3 of the Planning Act, the question of whether the Secretary of State had regard to the Paris agreements when determining the desirability of mitigating and adapting to climate change. Again, not controversial that it hadn't been taken into account. The question was, should the Secretary of State have taken it into account? An answer came there back, yes, it was clearly material had they considered whether the Paris Agreement was material to their consideration of the desirability of mitigating and adapting to climate change. They plainly would have done, it would have been irrational not to do so. In addition, the court held, although because it had remitted it back, I didn't go much further than this, that the AMPS needs to take into account climate change effects beyond 2020, and that will be a matter for the Secretary of State when they come to redo the AMPS. Heathrow is now, I'll come back to this slightly later on, but going back to, is going up to, sorry, the Supreme Court on appeal. The only grounds that's got permission, the only grounds that have got permission are the climate change grounds. So we will see in due course where that takes us. Stephen, if I could have a slide, please. Thank you. 2 further cases this year following on from Heathrow and perhaps inspired, I think, to some extent by the success in that case. Packham, another challenge to the decision to proceed with HS2. In this case, the decision to go ahead following the Oak Review report. Again, a number of grounds. The climate change grounds were firstly that the report had failed to take into account the undertaker's expectation that carbon emissions wouldn't be at the low end of the predicted range and therefore were likely to be in excess of that. And secondly, that it failed to address the effect of greenhouse gases in the period leading up to 2050 and not just 2050 and beyond. Both of those failed. The first one just was not a fair reading. It had been taken into account. The second one, the court was at some pains to stress that these were very different circumstances to those which arose in the Heathrow case. The Climate Change Act has been amended last August, I think, 2019, and now reflects the Paris Agreement, the net zero target. And the claimant had accepted that the report and the decision the decision to proceed with HS2 took that target into and Paris Agreement commitments into account. And so the circumstances, the unusual circumstances really, which arose in Heathrow where it was accepted and that those simply hadn't been considered, didn't arise. The challenge on the basis that it didn't grapple with the importance of reducing cumulative emissions before 2050, again, was rejected as not being a fair reading. It was held that the decision did consider the effect, report and decision did consider effects before and after, and that it was obvious from the report that although the construction phase, which obviously predates 2050, is going to increase carbon emissions, the overall effect of the scheme is offset by carbon savings over a longer period of time, and so it had been considered and properly dealt with. Next slide, please. And then the final case we've seen this year, ClientEarth development consent order for an NSIP, in this case, 2 greenhouse gas generating power stations. It went to an examining authority. The panel concluded that there was no need for the need for the installations hadn't been made out. And although, therefore, there were significant adverse impacts in terms of the generation of greenhouse gases, which went probably over and above what the applicant had estimated, although somewhat low, somewhere in the middle, although difficult to predict exactly where objectors were predicting. There was no need which would be capable of outweighing those adverse impacts. The Secretary of State granted the consent order anyway, because disagreed that there was no need, and so a great deal of this judgment is given over to consideration of what need under the MPS means in this context. But there are also some relevant passages on climate change, and there was a challenge that there had been a failure to weigh the adverse impact in the balance. That was rejected again on the basis that that had been done. It was just that the Secretary of State disagreed as to the balance to be struck. And there was a further challenge on the basis that the panel had explained that they hadn't considered the change in the Climate Change Act from an 80% reduction on 1990 baseline to net zero, and that was for the Secretary of State. There was a challenge to how the Secretary of State had dealt with that, and the court took the opportunity to remind everybody that at the moment the standard of review is irrationality. If it's been taken into account, the weight to be given to it is a matter for the decision maker. And so, wrapping up, really, I think the question is where do we go from here? I think it's very likely that we will continue to see, and probably an increase in litigation around climate change issues. The last 2 cases I just discussed, slightly perhaps a sense of rowing back or drawing a line in the sand from where it looks that we might be going post Heathrow, but I suspect we will continue to see development, maybe expansion in this area. I don't know if anyone who is listening to this webinar was at the virtual UK Law Conference a couple of weeks ago, but anyone who was will have heard Lord Harmwell's interesting after dinner talk there on the role of litigation in dealing with climate change. It is something I expect will be a growth area. It's going to be interesting to see what the Supreme Court makes of Heathrow when it goes up to there. As I say, there are four attempts to appeal the Court of Appeal decision on a variety of grounds, and the only grounds that have succeeded are whether the failure to take account of the climate change commitments in the Paris Agreement whether that failure to take those into account rendered the decision unlawful or not. Everything else has been refused permission to go up. So it's going to be something to keep an eye on for the future. Thank you. That's everything from me, but I will look forward to seeing any questions.
Right. We're dealing now with some other cases of interest, and the topics I'm going to address are waste related to begin with, waste shipment offences and waste exemptions, a case on legal privilege, and on habitats. I need to turn my video on. I'm just going to do that. Excuse me for a moment. Great, now you can see me in all my glory. Sorry about that. So, first of all, waste shipment offences. There was a case that went to the Court of Appeal Criminal Division, Biffa Waste Services. There's been, as you know, a lot of publicity around waste from the UK turning up and being improperly dealt with in other jurisdictions. This involved a shipment of what purported to be waste paper to China by Biffa. It turned out to be contaminated with a lot of very unsavoury things in terms of domestic waste. I won't disgust you with saying what was in there, but you can read it for yourself in the judgment. And the Biffa were convicted of shipping waste to China, which is a non-OECD country, contrary to the waste shipment regulations. They basically said, well, it's okay because it's essentially waste paper, which is allowed to be shipped to non-OECD countries. And they attempted to call all sorts of expert evidence in the trial to show that China was quite happy to accept this, that China had equipment that could deal with that sort of contamination of the waste without causing problems, and that the paper met Chinese internal standards. The trial judge disallowed that evidence, and Biffa appealed against that. So the question really was, what evidence is relevant to the legal question, which is for the jury, whether the level of contamination of the waste is more than minimal. And basically the Court of Appeal said the expert evidence is not relevant. We're not concerned with what China might or might not regard as acceptable, because what matters is the status of the material when it leaves the UK, when it begins its journey. So it's really a very simple question for the jury, which is, can you say that the level of contamination found is so small as to be minimal? So that's, in many ways, a bit of a blow to waste exporters who find they have problems with their shipments and then try to get out of that by bringing expert evidence to say, well, it's not so bad after all, it can be dealt with properly in Pakistan or Italy or China or wherever it's going to, and they're quite happy to have it. The other point, which I think is worth bearing in mind as well from a practical point of view, is that Biffa called its chief executive officer, who in chief in the trial made various remarks which suggested that Biffa was a very responsible company. It would be completely anathema to it to commit this sort of offence. And the Environment Agency then said, well, if that's what you're alleging, you're giving an impression that you are of good character. We want to adduce evidence as to your bad character and the convictions you've had for various environmental and health and safety offences. So that evidence was let in. Biffa appealed against that, and the Court of Appeal said, well, it's really a matter for the judge. If the judge thinks that you're giving a possibly misleading impression of your good character, then the judge is within his rights to say you can have brought in against you evidence of your bad character. So that's something to be very aware of, I think, if you're acting for companies. Companies these days, with their environmental and social policies, are always very keen, if they're accused of something, to bring those policies up and say, look, what good eggs we are, we've got these policies in place. You may need to gently discourage them from that, or at least to consider whether they've got any skeletons in the cupboard in terms of convictions that might be brought up against them if they do bring that favourable evidence in. Another case on waste, Mustafa. Mustafa and others were directors of a company which basically collected a whole lot of waste wood at a site. They did so under an exemption, one of the exemptions, the T exemptions, which apply under the environmental permitting regulations, allowing you to keep certain quantities of waste wood. They exceeded those quantities. Officers went along, discovered there was far more wood there than the exemption quantity allowed, and also that there were dust problems being created which were causing complaints from neighbours. The company did nothing about it. The company went into liquidation, was wound up. The company couldn't be prosecuted, so the agency prosecuted Mr. Mustafa and other directors. And they said, well, the company had an exemption. It had an exemption registered with the Environment Agency, and therefore we're entitled to rely on that to say we're exempt. And it's terribly important that people are entitled to rely on exemptions because it's a public register. And if you're dealing with a company, you should be able to say definitively it's got an exemption because the exemption is there on the register. The Court of Appeal really had no truck with that. They said that to be exempt, you must not only be registered, but you must also do two other things. One is to satisfy the specific conditions of exemption, for example, the quantities you're allowed to keep. And secondly, to be consistent with the objectives of the Waste Framework Directive, that you're not endangering human health or the environment. And on that basis, plainly, there was not a valid exemption. So I think the message from that is, if you're dealing with a company that says, I'm operating lawfully, I've got an exemption registered, you have to look a bit more carefully than that in terms of due diligence. Then a case on legal advice privilege. This, of course, isn't specifically environmental, but I think it has some quite big implications for environmental lawyers or litigators. It was a case a judicial review brought against the Civil Aviation Authority by an airline called Jet2. And the Civil Aviation Authority had criticised Jet2 in a press release. Jet2 had taken exception to that and brought a judicial review against the Civil Aviation Authority, and as part of that judicial review, they wanted to see the legal advice which the Civil Aviation Authority had received from its in-house lawyers on the matter, and also the internal email communications between officers within the authority and the lawyers. And the Civil Aviation Authority said, no, that's all within legal advice privileges, the purpose of giving legal advice. So the Court of Appeal had to go through quite a maze of conflicting authorities. Not a very easy area, this. But they said that legal advice privilege is governed by the dominant purpose test. What's the dominant purpose of the communication? If its dominant purpose is a legal one, getting legal advice, you're privileged. If it's a commercial one, you're making general commercial discussions or general commercial advice, or if you're a public body, for your public purposes, having a discussion, then it's not. And what happened in that case was that there were a lot of emails, as they tend to be these days, were sent and copied around to numerous people, some of whom were lawyers. And the Court of Appeal said, well, the fact that a lawyer is among the recipients doesn't make it legally privileged. It doesn't follow that's the dominant purpose. You might be sending an email for a commercial purpose, but copying in your lawyers because you think they ought to know, or you may want to get advice from them at some point in the future. So I think it's quite an interesting case, I think, in some respects, because My experience suggests that quite often when companies get into trouble with the Environment Agency or some other regulator, it doesn't come out of the blue. Quite often there's been quite a lot of correspondence that's gone on between the company and the Environment Agency, where each is setting out their stall and their legal arguments and so on. And that's probably been the subject of an awful lot of internal email discussions on both sides. So some of that discussion, which you think may be privileged, may not be quite as privileged necessarily as you think. So worth keeping in mind. Then two cases on habitats and species. We're sort of at the tail end, aren't we, of the Court of Justice of the EU handing down decisions that are going to be binding on the UK courts. When we come to the end of the transition period, they won't anymore, but these are two which will be binding unless the House of Lords decides to overrule them. And as we know, the government's actually consulting on whether courts lower than the Supreme Court may be able to do that in future. So at the moment, it's just the Supreme Court that can overturn Court of Justice authority. There's a consultation, might it be the Court of Appeal, or even, which would be extraordinary, the High Court. But anyway, these two cases, the first one I'm not going to attempt to pronounce, but it involved this bird, the black tern, which lived in an area which was subject to heavy drainage in Schleswig-Holstein, and there were drainage pumps operated by public authorities which kept the water levels low, and it was said that was damaging the habitat of the black tern. And a German nature conservation body brought a claim. Interestingly, it wasn't under the Habitats Directive or the Birds Directive, it was actually under the Environmental Liability Directive, saying that these activities have got to stop because they are having an adverse impact in terms of the Environmental Liability Directive on the protected sites. And the question was, were these activities, which had been going on for years and years, of the automatic pumps operating, normal activities, normal agricultural drainage activities, which were not significant damage for the purposes of the Environmental Liability Directive? And the Court of Justice, in its inimitably, I think, sort of inventive way, found, spelled out from somewhere, it doesn't exist in the print, but they spelled it out, a connection between the Habitats and Birds Directive and the Environmental Liability Directive, and said that an activity can't be a normal activity for the purposes of the Environmental Liability Directive, even if it's been carried on for many, many years, and it's quite usual in that sense, if it's being carried out in a way which is contrary to the conservation objectives laid down or the general spirit and purpose of the Environmental Liability Directive, of the Birds and the Habitats Directive. So a linkage there. It does present to my mind some interesting thoughts about how the Environmental Liability Directive might be used in future by conservation bodies alongside those other directives which they're very familiar with and well used to using. And then finally, our old friend, the European hamster, sometimes known as the Grand Hamster of Alsace, nemesis of many a project. It always seems to pop up out of its burrow and scupper some grand scheme. And here it was popping up again in Vienna this time. They're everywhere. What happened was very commonplace facts that a developer was wanting to develop some property in the suburbs of Vienna. There were what appeared to be disused Grand Hamster of Alsace burrows around, and essentially work was carried out to duff up the burrows and make them uninhabitable, or rather uncongenial to the hamsters. And a prosecution followed of the individual concerned, who said, well, it's okay, whilst the legislation says you can't destroy breeding sites or resting places, there weren't any hamsters resting there at the time. And the Court of Justice, I think not surprisingly, said, well, you don't have to have the animals resting there. The question is, for the national court, is there a likelihood that they are going to return at some point? And if you harm their burrow or nest or bat cavity or whatever it is, and it's likely they're going to come back, then you are in breach of that requirement. So again, a very common sense sort of approach. We'll have to see, won't we, how these decisions and how the European law on habitats sort of fares when we get into the bold new world of post-EU transition. So I'm going to stop sharing at that point, and we'll come back into full screen. And now I think we've had a few questions. Yeah, there's one question about the Jet 2 case. It said this seems to be a continuation of the difficult situation of in-house lawyers and how they educate their client company colleagues, which prevailed even when I, anonymous, was in-house in 1980-81. Well, yes, of course. I mean, people just don't get this, do they? I mean, if they're within a company, they're communicating with the lawyer, they think, oh, well, I'm talking to my lawyer, therefore it must be all secret. Well, it's not the case at all. So, yeah, I mean, a lot of education is needed, I think. I think just as much actually within the civil service and public bodies as within companies, really. Celina, I noticed you had a question, you might have answered it already, but it might be worth mentioning about the significance of the air quality to local plans. Do you want to say anything on that?
Well, it's a good question, but and it was the one that was directed and dealt with in both Shirley cases, in effect. And it's not how do the targets have to be met through local plans, in effect. They don't. The issue is you've got the directive and it's transposed by the regulations, and as a member state, we were required to respond to the air quality directive by making, finding out where there were breaches of the limitations and they'd failed to meet them. And thereafter, it is, what do you do in response to that? So firstly, find out. I know this is oversimplified. Find out. And then what do you do when you find out? You, as the government, has to go and put forward your plan. That is your duty. You must do that. And then implement it. There is no direct, I don't want to say direct effect because that's a European term, but there is no specific requirement within the local plan system to say we are meeting the air quality directive limitations through our policies. The response on a local level is through the Environment Act, which says they have duties also themselves to go and find out whether they've got breaches locally and in their area. And in response to that, they themselves must either, if they find breaches, put in place the management area and have an action plan. In terms of what you do in planning decisions, so when you're making a decision under section 38.6, air quality is just another material consideration, but clearly can have sufficient force to have as great an impact to refuse the decision. So hopefully it's not direct applicability. It's what do you do when you find, what do you do as a consequence of the air quality directive? I hope that clears it up. Oh, you're on mute, Stephen. You're on mute. Can't hear you.
I've got a window of the question open in front of my muting button.
Ah.
So
you've gone mute again.
So I've muted myself again. I've muted all over the place. Anyway, there was a question, I think, which I'm going to look at the question again now, having muted myself. If the local authority has declared a climate emergency with a 2030 deadline, how does that conflict with air quality timescale targets? So I don't know, any thoughts, Rachel, did you want to say anything on that? The possible conflict between climate emergencies, which a number of local authorities these days are declaring, left, right and centre, and their quality targets, or in Celina, I don't mind.
Yeah, I have to say it's not something I've considered. If either, have I taken myself off mute? $1 million question, yes. I don't know what the answer to that is. Celina, I don't know if you've I happen to have been asked before, so I do. With the greatest respect to those who are declaring these emergencies, I don't think it means anything legally.
It is just almost a policy declaration. There is no legal consequence of declaring an emergency. Clearly, that's a difference between meeting the target, beating net zero by 2050, which obviously was a legal, new legal provision, and that is something we must build up to. So there is nothing that a local authority specifically has to do once it has declared an emergency, which makes it sound a bit flabby, but maybe because it is, but it's an important thing to know about. But there's no specific consequence, unless Stephen, you think there is. I don't know.
No, I was just going to say, I mean, there is no specific consequence, except I think some local authorities haven't they, used the fact they have declared a climate emergency as part of their reasons for refusing planning permission, I gather. I think a few examples of that, which I've noted, don't think any have gone to court yet, but I have noted in, planning magazine and stuff that some authorities have said, I mean, there may well be other grounds as well. It may not just be that we've declared a climate emergency, but that certainly figures in their reasons. So, I mean, it can't be too long, I suspect, before local authority does rely on that in some way, which prompts someone to challenge them. But anyway, we'll see.
Just something to pick up from the questions that were coming through, Stephen, whilst you were talking. Someone helpfully pointed out that ClientEarth has been granted permission to appeal. That's the last of the 3 cases I was discussing. And I knew permission was being sought, but it's apparently been granted this morning. And there is a link to ClientEarth's press release in the question and answer chat, which I commend as a press release, because unusually it actually sets out what the grounds that have been granted permission are, and it looks like it's going to be very interesting. So that's definitely, if you're interested in climate change litigation, that looks like it's going to be one to watch.
Is that the Drax one, Rachel?
Yeah, that's the one.
Ah, yeah.
Yeah.
Well, the funny thing about Drax is obviously that it's about, for me anyway, is about challenging the NPS.
Yeah, but it looks like they've been given permission on how to, let me just see if I can find it in my browser. So some of it is about the interpretation of the NPS as a ground on that regarding contribution to need, but it looks like their permission's also been granted on the approach to considering projects' climate and greenhouse gas impacts under the policy, and the approach to balancing the adverse impacts against benefits. So it looks like it goes.
It may be, yeah. I mean, the interesting thing about that decision is obviously that the examining authority was prepared to go quite far down that particular, I don't want to call it rabbit hole, maybe, an Alsace hamster nest, but and the Secretary of State rode that back. So yeah, well, very interesting to see what comes out of that.
It's really interesting, and I'm very grateful for that being raised.
I think there's one or two other things in the wings on climate change. I think there's a challenge coming up to this big new coal mine, isn't there, in Cumbria, on climate change grounds. I think that gets to court at some point this year. There is also the case that I was involved with, which is a challenge effectively by Greenpeace to the grant of exploration and production licenses to BP and Ithaca oil companies, where it said that they didn't address, and the government didn't get them to address adequately, the climate change consequences of the use of the product, not the process of actually extracting it, but the end use effects of using all the gas, etc., as part of the environmental impact assessment process. Now, I was doing that case in the High Court for BP, but sadly for me, we identified the fact it really should have been brought into Scotland, so it's now been kicked up to the Court of Session. So that sort of takes me out of the equation a bit. So, but anyway, it'll be interesting to see how that one goes too. So let's just have a look. I think this might have to be the last question. Isn't it going to be difficult to justify decisions on the basis of a climate emergency in one authority area if it doesn't apply in another, maybe next door. Climate is, after all, an international issue. So I suppose it's really saying, well, it's pretty pointless declaring a climate emergency in your area, because nothing's going to happen unless everybody else does. I mean, it's a bit like all those London authorities who said they were, in the days of CND, nuclear-free zones, as though if a nuclear bomb was dropped on Britain, they would, the radiation wouldn't affect their area. But well, I sort of think they're kind of rather grand gestures at the moment, the declarations. I'm not sure I would derive too much from them, actually. I'm sure it makes, I don't want to decry it, because I mean, climate change is a big issue, but it certainly makes people feel, I'm sure, comfortable that their authorities take it seriously and has declared that. But in legal terms, I don't think at the moment it has a great deal of impact. Okay, well, I think maybe we should draw stumps there. I hope that's been useful. I think we've probably answered all your questions. Just two things to say. One is that a lot of these cases that we've covered are actually covered in the newsletter, which we've been publishing. Darby, our editor, has been publishing this newsletter every week, bless him, since lockdown. They can all be found on the on our website, and they include certainly all of the cases which I've mentioned in my session are there, including the Grand Hamster is there in all his glory, or her glory, and I think the other cases as well you will find there. So that's a good resource worth keeping up with. We have another, and I think our last 39 from 39 webinar next week. I believe it's on local plans from memory. So look out for that. I'm not involved in that, so I won't be seeing you. So I'll just say, I hope you all have a very nice summer. You're able to get some break somewhere, and stay safe. And we look forward to seeing you all again online, or even maybe in reality.
In reality, yes.
In the autumn. Okay. Thanks very much for joining us, and have a good summer from me.
Thank you very much, everybody. Bye.
Thanks.